Be advised, the opinions and views of the hosts and guests do not reflect those of the station.
Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment. Making life interesting. Enjoy their efforts, respect them. They help shape our world.
Good evening, ladies and gentlemen. Welcome on Intellectual Property right here on Global News Network. I'm your host, Attorney Sarah Sugitan. For tonight, we are going to feature 4 mediators from the Intellectual Property Office of the Philippines. And for the first half, we have Ms. Gloria Seno and Mr. Isagani Tan to my right. Good evening, ladies and gentlemen.
Good evening, Sarah.
Yes. Well, we'll start off with the questions that we have prepared for you. First of all, you are not lawyers. You're not practicing law, or are you not really?
No, we're not.
You're not.
But both of us are not.
Both of you are not, and
Yes.
yet you are into intellectual property. So how did you get into this very specialized field, should I say? So we'll start with Ms. Gloria Seno.
Yes, actually, I was involved in 2001. There was an initiative in the Philippine judiciary. It was termed to me as there are winds of change going to go through the judiciary. And it meant that the judiciary was going to have the mediation initiative. So they had first the court-annexed mediation, and this was primarily under the juris program funded by Canada.
So you were with the Supreme Court at that
Actually, I
time.
was called by PhilJA, the Philippine Judicial Academy. They were looking for trainers in mediation, and afterwards, of course, we had to do mediation too, and that was the court annex mediation, 2001. After that, they introduced mediation to the various agencies also in the Philippines, and among them, very recently, is the Intellectual Property Office. So there is now mediation in the Intellectual Property Office, and
You're active in both the
yes,
Supreme Court.
I'm
and the
active in
Intellectual
both. And by the way, over at the Juris Project, Gani Tan was also there. He was the model courts manager for the 2 sites, of the model courts of that project.
Mr. Tan, it's really great to have a non-lawyer managing courts, because usually lawyers get really, or at least specialists really get into the system, and sometimes they need someone to take stock of the situation. How about you? How did you get into mediation?
Well, getting into mediation for me is quite a long process. It starts off with my interaction with facilitation and a lot of advocacies for development. But I am actually scouted on in Bacolod City, where a model court site was actually being established under the Supreme Court's Action Program for Judicial Reform, and specifically on the Juris Project.
You're from
where
Bacolod?
Ms. I'm from Bacolod
You're from
City.
Bacolod.
Yes.
Okay, I see.
And there, they were scouting for people who are into the development field, particularly in community service. And since I'm very active in that part of the country, some peers in the University of the Philippines actually asked me to actually take on the challenge of assembling a pool of mediators from different areas. So that explains why we have a multidisciplinary pool of mediators in the Supreme Court, because of the paradigm shift, the shift from a lawyer-led practice in terms of dispute settlement, but actually breaking down the walls and ensuring that everybody can actually participate in the judicial reform process. So a year after 2003, I was invited to actually handle the task of becoming model courts manager, and I was sent to Manila to actually focus on several regional sites. And from there on, 5 to 6 years down the road, we were already exploring other possibilities of opening up alternative dispute resolution and mediation. And one of the actually field that the promise of mediation is very good is the intellectual property field. And because of that, our team in juries in the Supreme Court tried to work and find ways and means to actually work closely with the Intellectual Property Office. And during the initial training, to bring together two groups, court annex mediators and intellectual property law practitioners, I had an opportunity to actually work with that batch. And we graduated and we finished off 16 of us. We call ourselves the Diamond Team. And we are now 3 to 4 months down the road working and addressing issues on intellectual property, particularly on trademarks. So that's where we're at.
So that's how you got into mediation.
Yes.
Both of you have been working with the Supreme Court for a long time on this.
Yes.
And as you said, you were, well, I think you're one of the pioneers of this wind of change. Wherein well, at least the vision is to bring parties together and be more participative in
Yes.
finding a resolution for a dispute. And personally, how do you feel about mediation? When you handle a case as a mediator, what are your considerations and how does it feel when a particular case has been settled? Ms. Gloria.
Oh, there is a very great deal of satisfaction, you know, when you settle a case, particularly if it's a difficult case and you're able to explore avenues and work through creative ways of expanding the pie for both parties and letting them come together and seeing that you know, it's not just this issue, that they could really get also settlement on a lot of other peripheral issues as well. And it's very satisfying.
It's very satisfying.
Yes,
How about
yeah.
you, Mr. Isaganitan? How do you feel about
the
mediation?
working and actually serving as a mediator is a very fulfilling task, you know? And not so many are into the practice, but sooner, okay, rather than later, we will know that many of us will end up becoming believers of the process of problem solving through bridging and the process of problem solving by looking at the interests of the parties more than just their initial positions. So the idea is not to make people fight against each other and they end up having a win-loss situation, but encouraging them to actually explore possibilities of solving their problems under a win-win environment and eventually ensuring that they will become friends as they move on.
As
and
they
then
move
take
on.
It is a global initiative. I mean, really, all over the world, it is a means of settling conflicts that is gaining a lot of ground very quickly instead of going through litigation.
So it is then a better alternative to litigation, would you
I
say?
would definitely say so, that it's a better alternative because it also provides both parties actually a lot of leeway and a lot of how do you call this? Not just the interest, but their participation in the process. You see, litigation, the parties have very little participation in the sense that the decision making is more towards a third party. But here in mediation, they are active participants in the problem solving process. So that would give both parties actually a lot of leeway.
If I, for example, can you invite our listeners, for example, if they have a pending case with the Intellectual Property Office, particularly in trademarks, these cases are automatically referred to mediation? Is that the case?
Well, those cases
yeah.
go through the Bureau of Legal
Yes.
Affairs, or Office of the Director General, and then that's where the cases are then referred to the mediation
to
office.
the mediation
Yes.
office. And then how do the parties select the mediators, for example, or a particular mediator to handle their case? How is it? How
Yes,
does that go?
they have the privilege of selection.
A particular
Yes,
mediator,
yeah.
and then from then on, the vision is to arrive at a win-win solution.
Yes, that's a win-win solution
Yes,
for
that's
both.
what I like. Kasi
Yes.
usually people think about litigation a little harshly, or even just filing a case.
That's true.
Takot na yung mga tao because you think technicalities, legal speak, and
Yes.
normally you just assign it to your lawyer and you just wait for the results after the case. But with mediation, you encourage their participation during the hearing. May hearing din
That
po yan,
is
di
not
ba?
just encouraged, but that's really welcome. And the more the parties are personally involved in the process, the better actually would be the outcome.
Oh, yes.
For those who are already into mediation or parties who knew for a fact that mediation is available, the filing of a case is actually what you would call the opening salvo. But they would expect that they will be able to talk things out with the other party, and that opportunity is legitimately and above board being given to them through mediation. That's why in the Intellectual Property Office, mediation is a welcome thing. And for parties to actually talk out their differences, the history of the case, and that is not happening in a litigation mode. Even in a quasi-judicial body like the IPO, it may not be forthcoming, because when it's referred to the Bureau of Legal Affairs, basically the idea is there's cold neutrality that is being expected from the hearing
mediator.
officer. But in mediation, there is a face, a friendly face, that's actually relating and dealing and interacting with the parties. And that actually prepares the way for solving their differences using the human factor. The feeling of being able to actually relate, and the feeling of actually looking at the good side of things and the positive side of things, and the feeling that eventually when the case is settled, they can look forward to better and more positive things in their life. It's not something like a long drawn out
Case,
winner
yeah.
take all
That's
situation.
true. Yeah.
And like cases that usually take, what, 10 years?
In
or
fact, that's really
11
one of the
years?
objectives of mediation. That is really to make to provide a speedier delivery of justice, and to provide also a greater level of satisfaction to the parties involved. And that's always one of the things. No? You sometimes you wait 20 years for a
Yes,
case to be settled, whereas here in mediation, so long as the parties are sincerely committed to the effort, the time component is very, very short. I mean, comparatively.
Are you talking just months, or also
Oh,
it can
yes,
also
yeah,
stretch
weeks.
to years? Weeks.
Weeks,
The resolution
months.
of a case
Yes,
can take
yes,
a few
weeks.
weeks.
And-
And I agree with you on that, the speedy delivery of justice, lalo na because intellectual property has a business aspect.
Yes.
And for the parties involved, you cannot not go into business
Exactly.
when you're sued for
Yes,
trademark
that's true.
cancellation or trademark infringement.
And it derails your focus, instead of putting your time and your energy on your business, you're derailed. Here's this case you have to face, and so the faster it gets resolved, the better for business.
And it's one way for businessmen, particularly those in trademarks, to get on top of a situation.
Yes.
Confront the other party who's brought a case before you, and then settle it the
Yeah.
way in terms of interest. What's your interest? What's
Yeah.
my interest? And
Yes.
how do you arrive at a good solution?
Absolutely.
Diba? Without
Yes.
having to tear each other apart for
Yes,
damages, or
yes,
have
yeah.
someone go to prison.
Yeah.
So, how about on a nationwide scale? Mediation is also being tapped to solve other cases other than intellectual property.
Oh yes, like for example, I already mentioned the Supreme Court initiative. That's the court annex mediation. Actually, that is now institutionalized in the judicial system. So cases in the MTC and the first level courts, they have mandatory mediation.
So they have no choice. They have to go through mediation.
Yes.
This is mandatory.
There is a second level of mediation right now, which is called the judicial dispute resolution. So if court annex mediation fails, it goes to judicial dispute resolution, which is still a form of mediation, but this time the ones who are acting as mediators are the judges themselves.
The judges
Yes.
themselves.
Yeah.
Let me also add into that, the national initiative to actually push for alternative means of dispute resolution, particularly mediation, is actually making waves, not only in the judicial realm. It's also actually coming down, being cascaded to the communities. So we have now community mediation initiatives. Tribal Justice even has now entertained the idea of actually surfacing that there are really strengths that we have even in our tribal justice system. And this is not in the traditional conventional court system that we have. So we expect that even in quasi-judicial bodies like the Intellectual Property Office, there could be more and more going for mediation, because if only parties can talk about it in a very friendly, non-hostile manner, for sure we can carve out, differences can be settled and smoothened out. That's why we are very optimistic that we are going to have a very good success rate this year when we
mediation.
pioneer mediation
Yeah.
at the Intellectual Property Office.
Have you handled a difficult party or a different difficult case in terms of intellectual property, or even for mediation in general, since you've been with mediation with the Supreme Court for a long time? Not really.
Actually, a lot of the cases in intellectual property, there is always some degree of difficulty because legislation regarding intellectual property is still very new. And so it's like open season for intellectual property cases. But there is an even more higher degree or a more complex degree of difficulty when it's a multi-party case. And so when there are several parties involved and you have to bring all of these parties together to come to an agreement, that also puts an added dimension to the complexity of a case. And yeah, I had a recent case on that, multi-party.
Okay, among the difficult cases also that one can possibly handle in IPO mediation are cases where it's transnational in character, where it actually cross and crisscross various national territories. And even when these cases are filed in the Philippines, the parties, especially if they are represented by their counsels, are a little bit tentative about how effectively can a Philippine settlement be made to bear upon other jurisdictions. But I think with an ever-increasing pool of confident mediators impressing upon the parties that what we are practicing here is also similar to whatever is being practiced anywhere in the world, I think there could be more and more cases where even if they are transnational in character, that can be settled in the Philippines and that can be made to bear upon other countries as well.
Ladies and gentlemen, I have here on my show a lady and a gentleman whom I'm going to call as peacemakers or peacekeepers. They are mediators, they're qualified, and if you have a pending intellectual property case or are planning to file a case that is intellectual property related, I'm going to give you a chance to hear their message to you in case, would of course prefer that you go through mediation. So, Miss Gloria Seno first, this camera please.
Now, my message really actually to all the parties out there, since I work very closely with the corporate world, I'm in the business world, and business is dependent on speed, on opportunity, and a case that you file will always have an impact on the business. So my advice really is, if there's any case you have, go for mediation, because mediation will give you very speedy delivery of resolution.
That is Miss Gloria Seno from the Intellectual Property Office's Mediation Center. And now we're going to hear from Mr. Isaganitan.
Yes, by my 2 cents worth of thoughts for parties who are a little bit not sure yet about mediation is for the Intellectual Property Office, and even with respect to other cases in other courts and all. It's best that we also try to put ourselves in the shoes of the other party or in the shoes of the other side. And when we are able to do that and we are being assisted by somebody who can only mean well and whose thoughts are looking after your best interest, like a mediator, go ahead. Don't hesitate to come forward and bring your case to the Intellectual Property Office, because there is a facility or an opportunity for you to talk to the other side in a very friendly atmosphere and explore possibilities of working together, of building enduring relationships, even when initially you are very quite unsure how the other side would relate to your business, to your trademark, to your patent, or even to your copyright. So for the time being, I believe, give IPO a chance, give mediation a chance, and I believe that at this time, it is best for you to come forward and get in touch with us, because we will be able to help you
through mediation. All right, speedier delivery of justice through mediation right here on the Intellectual Property Office of the Philippines. You've heard from Ms. Gloria Seno and Mr. Isaganitan of the Mediation Center of the Intellectual Property Office of the Philippines. When we return, more on mediation right here on Global News Network.
Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment, making life interesting. Enjoy their efforts, respect them. They help shape our world. Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment, making life interesting. Enjoy their efforts, respect them. They help shape our world.
Welcome back. You are still on Intellectual Property right here on GNN. Earlier, you heard Mr. Isagani Tan and Ms. Gloria Seno of the Intellectual Property Office's Mediation Center. The other half of the show is dedicated to profiling two other mediators, Attorney Estrelita Abelardo and Attorney Gladys Vilches. Good evening, ladies.
Good evening.
Yeah, so I'm going to start off with how did you get into intellectual property and now mediation? So we'll start with Attorney Gladys Vilches.
Well, I got into intellectual property first, well, when I was a relatively new lawyer. I used to work with the University of the Philippines legal office, and there our boss was very much concerned and aware of intellectual property rights. So she introduced the concept of intellectual property in the university and the concept of putting up IP policies in universities. So because of that, I got interested in intellectual property, and then I applied to work with the Intellectual Property Office. And then in 2001, I started working with the Intellectual Property Office as a hearing officer with the Bureau of Legal Affairs, the function of which is to hear and adjudicate cases involving intellectual property infringement, and of course the cancellation, opposition of trademarks, and so on. But in 2000, but these are litigious in other words. So, but in 2003. The Intellectual Property Office started introducing the mediation procedure. So as early as 2003, actually, there were already programs to introduce mediation in the Intellectual Property Office. However, at that time, the mediation process was still voluntary, so that not many litigants or parties would avail. But starting this year, when we started with the training of, and there was also an institutionalization of the mediation process, such that it has become mandatory. So that's it.
That's how you got involved in intellectual property. Attorney Abelardo, I understand you were also with the Intellectual Property Office of the Philippines.
Yeah, I got involved with intellectual property when I started there in 1969. First as a stenographic reporter, and then a trademark examiner, and of course the later part of my service, 20 years of, more than 20 years of them as hearing officer and director of the Bureau of Legal Affairs. So I got involved in mediation when in 2003, as Gladys has said, mediation has become part of inter-parties cases, but it is rather optional. But in 2010, after I retired, and there was mediation included now as part of the process, I become interested, and I attended training in mediation.
You were both with the Bureau of Legal Affairs, and it's the hearing arm or the
the
quasi-judicial arm of the Intellectual Property Office. Kumbaga po, parang yun ang korte
Litigation.
sa loob ng ng IPO. Yes, and now you are mediators. You are both in the private sector. Are there rules that apply and don't apply to a hearing officer and a mediator, Attorney Abelardo?
Yes, of course. As a hearing officer or as a director of the Bureau of Legal Affairs, you cannot be so close to either one of the parties. You've got to be fair in dealing with the parties, and of course be not only fair but with a little distance, and because you are expected to resolve cases in a fair and judicious manner. But in case of mediation, you can assist the parties, facilitate the settlement between them in a cost-effective and more friendly manner.
Magkaiba po. Kumbaga, the
Magkaiba.
scenario between a courtroom, which is what the BLA is, and then a mediation scenario. Kumbaga, Attorney Vilches, so what do you think? How does it feel to transition from a hearing officer and now as a mediator? Is there a difference for you?
Yeah, actually, there's quite a lot of difference because as a hearing officer, you act as some sort of a judge, and you sit there, you listen to the parties equally, and then you're supposed to be cold and neutral, and then you cannot be so over friendly with the parties. So after the hearings, you just like everybody leaves, and then you just stay there, you study the cases, and then you only consider the evidences presented before you. Those evidence that are which are not there, you cannot imagine things or like that. But well, as a mediator, of course, the parties are there, and you're supposed to be you're supposed to facilitate the negotiations between the parties. So you are friendly with them. The atmosphere is more friendly, and of course, you're not supposed to have bias as well. But you cannot be cold and neutral. You have to be encouraging. You encourage the parties to settle with each other. So even after the procedure, for example, then you can laugh with them like that, and then you can actually...
It's more informal.
Yes, it's more informal.
And I think what's good about mediation is you take away the factor of intimidation from the parties, because anyone can admit it's intimidating to come into a courtroom. And of course, you'll have to practice the, as you said, cold neutrality of a judge when you hear their dispute and they present their cases. And usually you deal with lawyers, or are there also parties who appear before the Bureau of Legal Affairs back then?
Well, before the Bureau of Legal Affairs, it's like really a court proceeding. So the parties may appear, of course, but they are always represented by their lawyers. So everything is legal, technical, even the rules of procedure, rules of evidence, it's very legal. And in fact, the rules of court is supplementary to that, to the rules of the Bureau of Legal Affairs. But in mediation, everything is friendly. And of course, there are rules of confidentiality like that, but really, there's a lot of difference.
Intellectual property is a very specialized term, even for the critical masses. And back then, were there many people who filed cases already on intellectual property? Were there already a lot of people aware and having disputes or conflicts on intellectual
This
property?
businessman, if they know that their interest will be damaged, they will file, surely. Most of them will file notice of opposition to trademark applications which have been published for opposition. And if they believe that their interest will be damaged by the registration of this trademark, then surely they will file a notice of opposition.
Well, you are into mediation. When a case is assigned to you, when parties choose you, because I understand you can choose one mediator rather for the resolution of a case. How do you go about studying your case, Attorney Vilches, or how do you go about the procedure of mediation for the parties?
Well, actually, for mediation for the parties, as a lawyer, of course, with background in intellectual property, it's a little bit of a challenge not to have some preconceived ideas about which trademark owner is really the owner and which one is just some sort of copying, or if this case is actually it pushes through, I mean the opposition case, who will win, like that. So what I actually do is I try to refrain from reading the case beforehand, and then try to cull the dispute or the issues from the parties themselves. So from the point of view of party A, for example, how does he see the issues, and then party B, like that. So that way I will have information firsthand from them, and from there try to see where they can meet. Because as an IP, intellectual property lawyer, if I will already have some prejudgment, it's kind of a challenge trying to maintain also some sort of neutrality there, which also has to be there.
And as lawyers, usually when you see a pleading, you read it. That's your tendency.
That's
so
right.
you go through the legalistic terms. So it is a challenge.
It's automatic, actually.
It's a
It is
discipline.
automatic,
Yes.
yes.
How about you, Attorney Abelardo? How do you go about handling a mediation case?
In mediation cases, I start with telling them the purpose of mediation, that we are there as mediator to facilitate the parties into a settlement, of course, in a win-win situation, and in a quick and cost-effective and a quick, speedy manner, no? But of course, before proceeding, I will tell them my involvement with the intellectual property office,
Your background. Yes.
my background first, because it's better to be truthful to them, so they will not say that there are secrets. No? Although of course the proceedings in mediation are confidential, and we let the parties know that they can trust the mediator because it will not leak. Because we do not have any record of the proceedings, and we are just there to help the parties settle their cases amicably.
As I understand, not anyone can be a mediator. There are standards. There is a qualification process. What are the criteria to become a mediator? What have you gone through in order to become a mediator, Attorney Vilches?
Oh, we had interviews, and then well, actually, in 2003, the first time I applied to be a mediator, there was an examination of some sort to find out the psychological makeup, I think, but they did. And then after that, we went through interviews, which we also went through in this mediation training, which we recently had. So I guess the profile that they were looking for is somebody of a mediator is somebody who has an open mind, who can look into, without prejudgment, the sides of both parties, like that. And then, of course, who can encourage parties to talk to each other, and somebody who has no preconceived notions about, attitudes of other people. Just open like that, and at the same time reasonable, I think. And
You don't have to be a lawyer in order to become a mediator. Is that correct?
No, I don't think so. In fact, we have very, very good mediators who are not lawyers.
Attorney Abelardo, what is the profile of a good mediator? What makes up a mediator for you?
A good mediator should be warm, friendly, and encourage the parties to settle in a cost-effective and a win-win situation. So we try our best to let the parties know that we are there to help them, and that they can solve the problem in a more friendly manner than going into litigation and doing it in an adversarial manner, like when we were still hearing officers and director of the Bureau of Legal Affairs. No? So the climate is very much different than when we are in an adversarial proceedings, when you go into mediation.
And it's actually a state policy to make judicial proceedings more or less adversarial, especially when it comes to life, liberty, and property. But with mediation, as Mrs. Gloria Seno earlier said, there's a wind of change, because we'd want, at least the judicial policies, to make the parties more involved and not just leave it to their lawyers, but be part of the solution, or be part in crafting the solution for problems. How do you feel? Have you with regard to your mediation function so far?
Well, it's actually fulfilling because when you see the party settling the case and you see both of them happy and smiling after the settlement, it's like you know that both of them got what they wanted, or at least if not everything, then terms which are acceptable to both of them. Unlike, for example, in litigation, when one party loses and one party wins, then you know that they will appeal and this will go all the way to the Supreme Court depending upon the decision of the party. So mediation, it makes you happy that at least parties have are happy about the results of the procedure.
And I think you have to be patient to be a mediator. I don't know if you maintain a cold neutrality of an impartial judge, or you have this situation where it's a courtroom proceeding, automatically people will behave, I think, or just keep to themselves. But with the warm or friendly atmosphere, people can be more prone towards exposing who they really are. They let themselves be vulnerable to the mediator and to the other party. So, I mean, you must need to, well, unburden yourself siguro some other way, or enjoy yourself some other way. Attorney Abelardo, how do you cope with the stress of becoming a mediator?
Mediation, I enjoy it because it is a complete turnaround of what I've been doing for the last 40 years. Yeah,
Kasi
because
you were...
what I was doing for the last 40 years is to litigate and resolve cases. Of course, one of the party will surely lose, and one of them will surely win and go to appeal the cases, not only in the Court of Appeals but also in the Supreme Court. Some of the parties, they repeat filing the cases for after 20 or 30 years.
They repeat. So they do that? They
The
refile
heirs.
cases?
This time, the heirs will file the opposition or
But that's a result of, kumbaga, unsatisfaction from a previous ruling. If they refile a case or they lose on a technicality, perhaps.
Maybe, but maybe if the case reaches the court and they do not agree with the decision, then when the opportunity comes again, they will file again the opposition. If another person who is now the heir or the predecessor of the original party.
And a case can go on
Go on and
forever.
on.
And well, it's difficult to be a judge, so to speak, when I mean, if you are overturned, or if you know that a party has not been totally happy with your judgment. So how do you cope with your functions as a mediator, or before as a hearing officer? Do you distress or anything, Attorney Vilches?
Oh yeah, distress, meaning after office hours,
Yes.
then you go somewhere, have coffee with fellow hearing officers, because you cannot have coffee with the litigants.
With litigants,
like that, or the usual, watch movies like that. But as a hearing officer, yes, it was pretty stressful in a sense that you're supposed to be a judge. So in a sense, you cannot be too close to the lawyers who are supposed to be your friends outside of the office. But they cannot be your friends. So that in itself is stressful. But as a mediator, there's really no stress there, because even if the parties at first would be not, there's some sort of a, say, hostile environment in the beginning, but after a while, when the parties start to open up, and after a while, things become more friendly. So being a mediator is, at least at these very early stages, I could say not at all stressful. Like being a hearing officer, that was more stressful.
How about you, Attorney Abelardo? How do you cope
in my
with stress?
case, when I was still the director of the Bureau of Legal Affairs, I know that when I resolve case or I decide the case, one will get mad at me and one will surely be happy.
So it's a given for you.
It's a given. But of course, I console myself by saying that I don't even know the parties. I only consider the evidence that are presented before me. And so I decide the cases fairly and judiciously. But in case of being mediator, you are not doing anything that is adversarial.
Yeah.
You are just facilitating.
What area of intellectual property is most interesting for you? Copyright, trademark, patents, utility model? Is there any specific area of intellectual property of most interest to you, Attorney Vilches?
Well, actually, intellectual property, all aspects are very interesting because one aspect like trademarks would be dealing with business, patents would be dealing with mostly sciences, and copyrights with the arts. So, at any given time, I'd be interested in one, and then another time the other, depending, of course, on the cases I'm handling. So there's always something new to learn in every aspect of intellectual property. It's a very interesting field.
How about you, Attorney Abelardo? Are you also a jack of all trades when it comes to intellectual property law?
But I have favorite. No? In trademark, if it is a trademark cases, even if I'm sleeping, I can resolve them.
Trademark cases.
Yeah, because I'm very familiar with the trademark laws. And of course, I've been a trademark examiner previously, no? So I can get along easily with any issue or any conflict about trademark.
Is it expensive to go through mediation, Attorney Vilches?
Oh no, not at all. It's not expensive. Definitely, it's less expensive than going through litigation because if you go through mediation, you pay a one-time fee with the Intellectual Property Office, and then at the moment, I believe that the fee for mediation would be 4,000 pesos per party. So and that would entitle each party, the
For
parties
6
to 2 sessions of mediation for 2 hours each.
For 2
I
hours.
understand. But of course, the parties can mediate for 60 days. That's the period for mediation. Yeah.
Yeah. So, Attorney Abelardo, have you handled a difficult case or difficult scenario as a mediator?
Yeah, there are times when parties wouldn't like to mediate because they will say that they would like that the issues in the case be resolved. Definitely, because there are litigious issues to be considered, but not only by the Bureau of Legal Affairs, but they will go up to the Court of
courts.
Appeals and also to the Supreme Court in order that the issue will be litigated.
So there are considerations
Yeah.
like that when it comes to parties.
You cannot avoid that. There are difficult parties, no, because they are not only thinking of the Philippine business, but also the global business of their clients.
Of their client. All right. So, Attorney Gladys Vilches, please invite our viewers who have a pending or will be filing a case soon with the Intellectual Property Office to opt for mediation. This camera, please.
Good evening, everyone. I would like to invite you to, for those people who have pending cases with the Bureau of Legal Affairs or those who are thinking of filing cases with the Bureau of Legal Affairs, I do encourage you to try the mediation procedure which is being made available by the Intellectual Property Office because as a former hearing officer and as an intellectual property practitioner, I assure you that it will be more beneficial and cost efficient in terms of time and finances to go through mediation.
There you have it, Attorney Gladys Vilches. Now we will have Attorney Estrelita Abelardo. This camera, please.
Okay, as a former director of the Bureau of Legal Affairs, I am now involved in mediation, and I can assure the parties that if they allow themselves to explore the possibility of settlement, and they can do so in a cost-effective manner and in a win-win situation, then they must do so in order to avoid too much cost of litigating some issues that have to be litigated in court. No? So, try mediation, and it is very much different from litigation.
From litigation. There you have it, Attorney Estrelita Abelardo and Attorney Gladys Vilches, who are both officers before of the Intellectual Property Office of the Philippines, and now they are in private practice. They are also certified mediators with the Intellectual Property Office. If you do have a pending case, or you're thinking of filing a case instead of opting for litigation, go through mediation. And of course, approach the Intellectual Property Office of the Philippines. We will be moving our office from Buendia to number 28 Upper McKinley Road, McKinley Hill Town Center in Taguig City. The trunk line remains the same, it's 238-6300, and the website is still www.ipophil.gov.ph. Thank you for joining us for another edition of Intellectual Property. I'm your host, Attorney Sarah Sugitan. Join me again next week right here on Global News Network.
Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment. Making life interesting. Enjoy their efforts. Respect them. They help shape our world.